Welcome back to this channel where we provide premium legal content. Today, in this series of videos, we want to look at some very important issues in our criminal jurisprudence, especially as it relates to conviction in a capital offense. What would be the likely decision of the court when it discovers that at the time of sentencing, the defendant or accused person is a woman? Not only that the accused person is a woman, but that she is pregnant. What will be the likely decision of the court? Secondly, what will be the likely decision of the court when the court finds out that the accused person or defendant at the time of the commission of the offense was someone below the age of 17? And third, what will be the likely decision of the court when the court finds out that the accused person or defendant was indeed insane at the time of the commission of the offense? Well, I would be right to presume that we should know, it should be a given, that upon the conclusion of trial, the next thing a court of law is expected to do is to proceed to pronounce a sentence, either or acquit or discharge the accused person. Whether or not that will be the case is what we are going to determine in this particular series of videos. Well, let's look at what the law says concerning someone who is indeed guilty in a capital offense but is a pregnant woman. By the provision of Section 376 as well as Section 368 of the Criminal Procedure Law, it provides that when a court discovers that a woman is pregnant at the time of sentencing, the right procedure, the right thing the court is expected to do is to commute that sentence of death that should have been passed on that woman to life imprisonment. Secondly, if you look at the provisions of Section 404 of the Administration of Criminal Justice Act, it provides that the sentence will not be passed until the child is delivered and weaned by the woman. You also see similar provision in Section 270 and 273 of the Criminal Procedure Code, as well as Section 302 of the Administration of Criminal Justice Law. One thing you should also notice, we might want to ask, how would the court determine or come to know that indeed this woman is pregnant if the pregnancy is not obvious? Well, this can be, known. The judge would get to know, usually, if the prosecution averts the mind of the court to this particular fact, or the defendant herself averts the mind of the court to this particular fact. And if the court is satisfied, usually by medical evidence, that indeed the defendant is someone who is with a child, the court would usually proceed not to pronounce a sentence of death or pronounce a sentence on the woman. Or rather, if it is under the Criminal Procedure Law, the sentence will be commuted to life imprisonment. Well, thank you very much for watching this video up to this point. One thing we need to remind you is that this channel requires your support to grow. You can support the growth of this channel by subscribing to this channel and clicking on the notification button when you do so that you can continue to be the first that receive any content that drops on this channel. And our next video will be looking at what would be the position, or what are the positions of the law concerning, one, a person who the court finds that was indeed insane at the time of the commission of the offense, and two, what will be the likely position of the court when the court finds out that the accused person or defendant, was a child or somebody below the age of 17. See you next time on our next video.